Welcome to another episode of This Is Fine, where we bring you the latest in government technology and cybersecurity while making sure you're entertained throughout our show. I'm your host, Matt Triner, CEO of Hunter Strategy, here to tackle the serious topics with a not so serious approach. Today, we're diving into determining the materiality in a digital forensics and incident response or DFIR situation. And who better to guide us through the maze of complexity than our two guests? First, we're joined by Lee Kim, Director of InfraGard National Capital Region. Lee is a licensed attorney and has had roles in the American Bar Association, National Cybersecurity and Education Center, and the U.S. Department of Homeland Security Analytic Exchange Program. Lee is a distinguished advisor in cybersecurity, data protection, privacy, and artificial intelligence, providing guidance to companies, nonprofits, legislators, and regulators. And secondly, we're joined by regular guest Jake Williams, the Vice President of Research and Development and Director of Hunter Labs from Hunter Strategy. Jake is a seasoned cybersecurity expert, bringing years of forensics and incident response, threat intelligence, and offensive methodologies. Jake is a two-time winner of the annual DC3 Forensics Challenge, former startup founder, and IONS faculty member. So buckle up, listeners, as we venture into the world of materiality and a deeper with our expert guests. So before we get started, because while we talk about digital forensics all the time here at Hunter, some of our listeners might not even know where we start with defining what is a digital forensic situation. So before we dive into the more kind of 201 and 301 questions, why don't we kind of define digital forensics for the layman? Lee, do you want to kick us off there?
Sure. So, from my perspective, digital forensics involves uh, essentially the collection, identification, aggregation, uh, chain of custody, all that of any kind of electronically stored information wherever it may be. Um, of course, forensics. When I hear forensics, I think about evidence, chain of custody, who has what, who has access to what are they doing with it, and how long is that information available? So, in a somewhat messy way, that's my worldview.
Yeah, having watched some of those close up, not being a forensicator myself, it looks like as much art as science going into the process. Jake, did you want to add to that at all?
No, I mean, I think, you bring up a good point there around art versus science, because I've never completed a forensic investigation. And I say completed in the sense that there's never not in a real world situation, there's never not been more to explore. We're always constrained by time and resources. And then, of course, what are the tactical things that we're trying to recover from an artifact perspective? What story are we trying to tell? And, ultimately, to your point about it being art, right? A bit of that is figuring out what do you focus on, right, to tell that story, and ultimately not introduce bias, right, in doing that by only selecting pieces of the story to tell, right? Make sure to look for exculpatory, evidence as well.
Yeah, I feel like a better way of saying forensics and incident response doesn't really end. You just at a certain point decide to stop. Uh, so I guess let's just while we're still on kind of 101 definitions, we're here to talk about materiality. How would you guys define the concept of materiality, right? I think that from my view, it's is this bit of evidence related to the incident or not? But I don't know if, again, not actually being a professional in this side of the space, I want to make sure that I check my preconceived notions before I dive into talking about kind of the more technical boundaries of that.
Yeah, sorry, Lee, do you want to take that first?
Sure, I'll take that first. I'll first talk about what I believe it's not. So, very quick story. When I was in law school many years ago, unfortunately, I was taking a property law class, and the concept of materiality had cropped up. And being a fairly dumb second year law student, I asked my then property law professor, Well, I don't understand this concept of materiality. What kind of material is it? You walked out. Of course, I got much, I think, a little bit smarter since that time and everything else, but I could tell you. So, materiality is not a physical material. Hopefully, no one thinks that, but it's confession time here. So that is what it is not. But what is it actually from a lawyer's perspective, which is what I am primarily? Um, Although I do work by day for a nonprofit called HIMSS, basically materiality is anything that essentially cuts the jugular vein of your company. It could be your crown jewels in terms of IP. It could be we aren't able to open our doors and sell our goods. It could be we have a e-commerce site where we're losing, bleeding millions of dollars. It could be something where it's financial, operational, functional, or in the realm of assets, our crown jewels, they were essentially absconded with or tampered, or we just can't get access to that critical data. So our products, services are hurting and or since I'm in healthcare, maybe our patients are in danger. So that's how I define it.
So, and it's interesting because that is a bit of a shift from how I defined it, because it was kind of anything related. And what I'm hearing, and Jake, I'm curious as to your take here, but what I'm hearing, and I'm going to use a physical analogy because that's how I understand these things, is if you're a bank and the only thing your customer cares about is in the bank vault, it might be important to describe how the robber traversed from the door to the bank vault. But if they stopped in the bathroom on the way, that is immaterial because there's nothing that customers care about in that bathroom.
Ooh, that's a really interesting analogy, but sure, okay. That's
I'm
yeah.
thinking of physical pen tests when I used to break into banks.
No, it's a good. I mean, I meant interesting, not in a pejorative, right? It's a really interesting way to kind of think about that. Yeah, yeah. I, you know, I think materiality is a really interesting topic because you know, if we come back to the legal definition, and the reason, of course, we're talking about materiality now is, the SEC's updated guidance for reporting material cybersecurity incidents. Folks keep calling it new guidance. I really feel like it's a bit of just clarification that if it's a material event, you don't get a pass to not report it just because cyber's involved. I don't think there was ever an intent for that to be the case, but certainly that's what we were seeing. I go back to TSC Industries versus Northway. I mean, this is, what, 40 some odd years ago here. And really that's the SEC. It's the case that defines foundationally what the SEC uses as definition for materiality. And that really comes down to anything that impacts the share price, right? So it's information that if it were known to a reasonable investor, would ultimately impact how they would vote, right? Now, of course, in this case, it was about hiding information, or that case is about hiding information, not disclosing information that may have influenced a vote, but certainly how you value a security is directly in line with that. It's really interesting because I do a lot of executive tabletops, and consistently when I ask executives what does materiality mean, they give lots of definitions, but rarely address share price. And you know, I think it's a really interesting. And Lee, I'm dying to know your opinion on this, right? Given that you're an actual lawyer, and I am very clearly not. But given that we see just about anything in the market that could be negative does impact share price for at least a short period, right? It's a blip. Markets hate uncertainty. How do we apply that from a cybersecurity standpoint? Like, what news of any cyber event would not move the share price? And I don't know. What are your thoughts on that?
Well, as a person who lightly invests, I think that's a very interesting question. And I hear you. I mean, it's very good to point out that the fact that the price of securities does move in the wake of an event. But if we look back at the Muddy Waters incident, we didn't see much of a impact as much as we thought we would in terms of um, share prices, which was very interesting. And for myself, again, a person who lightly invests, I think that when there's a breach or other things that happen, I'm always surprised how the share price doesn't tank even more in spite of a really super bad breach, something that's really like drastic in the news. But I do believe that an informed shareholder, of course, does have the right to understand what's happening with that company. I think at the end of the day, what we need to understand is whether you are a big household name company or you're a smaller company that happens to be publicly traded. It all depends on what is that company's lifeblood in terms of products, services, um, and is whatever happened in a cyber um, incident perspective, is that something that impacts, like I said, a jugular vein or the aorta of the company? And if it does, I would at least argue if I were working as legal counsel, I'd say, well, yes, Mr. or Ms. Sizzo, I hear what you're saying. It might have been a big technical incident, but did it really impact something that's either a huge moneymaker for us and or something so vital that we can't keep the lights on, the flow of electrons moving the right way. So that's how I would view that from a big picture perspective. If I were reviewing and validating to confirm, yes, this in my legal determination is material.
Sure.
So I think that that actually kind of leads us into the first, kind of more advanced question here is how has this concept have materiality changed now that there are kind of new regulatory frameworks and compliance requirements that affect different types of entities? Like I think we gave a good layman definition, and I thank you, Lee, for kind of correcting my much broader definition. That was kind of how I conceived it initially. But do laws and specific regulations, and the one that comes in mind is SEC related, right? Because that kind of was probably the broadest sweeping change that we've seen in the need to report incidents in the last decade. And when I say broadest, I mean affecting the most companies, right? You always had to do it if you had a defense contract. There's been healthcare requirements with HHS for years now, but just kind of stop saying any publicly traded company is a wide cut. How have those different regulations affected the definition of materiality, or have they not? Have they been silent on that? And that's an interesting thing in and of itself, in my opinion.
Well, I I think that it's an interesting question you raise in terms of what materiality is. The SEC rules certainly talks about materiality. Other regulations and laws, though, they don't necessarily talk about materiality, but they do talk about the notion, of course, what triggers a reportable breach. So I think that nowadays, whether I'm here in the US, you guys are here in the States, but whether it's domestic or international, what really matters is, am I in a situation where the regulators may be breathing down my neck and possibly investigating me, or where I have a reportable breach? And once that is the gates open as to either of those, or maybe both, that's when you have the, oh shit, what do we do? Unless, of course, we have a plan of action, right? So that's where my head goes whenever you ask the question of materiality. Yes, it could be materiality in some cases, but in other cases, it's the duty to hopefully get our plan in place about how we report it to regulators, even proactively, even ahead of when there's a problem. And if we're shit, we just have 72 hours to report this thing, which I do support for my organization from a legal cyber perspective too. We haven't, well, notwithstanding that, I think that when GDPR and things like that came into play with the 72-hour time period, it was kind of shocking for many of us. And regardless of whether we're large or small, nonprofit, for profit, we are like, very much feeling the heat of regulators and what they can do, the most recent of which, in terms of data protection laws, regulations around the globe, I feel that we should be concerned about is the Indian data protection law, which was passed just the other year. And they're still in the process, as I understand it, of getting together a data protection board to oversee whether you're in compliance. But that's yet another thing that we need to look out for in our complex web of laws and regulations. So, sorry, I know you guys never thought that you'd have to deal with laws or regulations when you first got into the biz, but here we are today.
I mean, I grew up in the Intel community, Matt, also I think a bit there, the thing that nobody shows on every spy movie out there is the number of lawyers in the room saying what you can and can't do. I think we were born and bred born and bred in the regulatory space, probably a little bit more than a lot of folks in cybersecurity. But yeah, I take your point.
Yeah, definitely. It's always interesting. You've got the actual lawyers, which are in the room less. Then you have the people that are there to represent the lawyers that are even less flexible than lawyers somehow. That tend to be in more of the meetings in that community, uh, and it's always fun to watch because I did it on the contract side, right? Or I've always done it on the contract side. So it's always interesting to watch two government folks disagree on what the lawyer would say if they were there, and getting to see how that shakes out is very very cultural in my experience. So one kind of follow up question is, just given the kind of I don't want to say flexible definition because I don't think that that's the right way of putting it, but given the broad definition, are there particular, frameworks or approaches or things that, because and the most hands-on I've been in DFIR is helping to write the report, right? Or really just editing the report that other people wrote and being that first set of eyes to be like, yeah, this chain doesn't make sense to me. Can somebody please clarify how we got from here to here, right? Because I'm reading this and I don't get it. Are there like approaches or ways that you can establish materiality in the context of a particular incident that kind of help the scrutability of the report, so to speak, of how it comes out of that?
I for what it's worth, I'll take this one first here and say, I've had the pleasure, displeasure, whatever, of dealing with the Indian regulators twice in person. Once I wasn't sure I would be leaving the country, and so it was a very, we'll call it, hostile situation, right? And one of the things I learned from that, and I've taken away from that, and I've tried to brief to others now that we have the materiality guidelines with SEC for cyber reporting, is hindsight bias is a big factor in the way we think about incidents. And there is a timeline, right? Obviously, it's 96 hours, but it's well, 4 business days, I guess, is a better way to say it. They're not measured in hours. 4 business days from the time we determine materiality, and then very clearly we can't use, per the regulation, undue delay in establishing that materiality. The problem is, in hindsight, it you may be able to step back and look and say, "Gosh, you clearly should have known then that it was material," and because of course we're using knowledge that we didn't have then but have now. And so one of the things that I've encouraged a lot of incident responders to do, particularly after that, after that experience with Indian regulators, again, that involved a lot of, second guessing, Monday morning quarterback. And when did you figure this out? When precisely did this information come to light? Is copious notes, time stamped copious notes. And it's interesting because over the years, legal counsel has traditionally been like, well, if it's in draft, be really careful about what we have. That's notes and raw stuff that can change over time. These are assessments. And, I've been telling folks, that particularly if you're deciding something's not material, checkpoint a report right then. I know it's extra work, right? It is. But checkpoint a report with, and even if you don't get all the grammar right and all the, may not be as polished a product, but then, right? Don't let it go, right? So that you've got that document to go back to if somebody challenges you. Literally a summation of, here's what we knew at the time we made the decision. These are the facts on which we base that. Because the facts, I mean, I don't want to say facts change over time, but what we learn, additional evidence surfaces, and that changes our assessments, including materiality. Lee, I'm dying to know thoughts on this.
Yeah, I think that that's a very sound point. I actually advocate for the same thing. I say to people, if you even have a phone call or Teams chat, even a conversation in the hall, make a note of who you're talking to, full names, timestamp, whatever, even if it's your own notes. Make sure that even if you wanted to, just from memory, if you're more of a audio kind of person, you could even record a voice memo to yourself saying, "Hey, I just had a discussion, da da da. These people were present. Here's what we discussed." Because that's absolutely correct. What you should be measured from is absolutely what you know at the time, not in retrospect. Oh, we should have seen that pattern or this pattern. Document is absolutely a defensible move on your part. Because nowadays, under SEC regulations and otherwise, not only do you have to defend your organization, you might even have to defend yourself, which is crazy to think about, but I think we know from the reality of litigation otherwise, yeah, it's for real. And the other thing that I would say is if you haven't done it yet, if you haven't defined materiality, what that is within your organization is, and as you can see from our different approaches, it really depends on what the priorities, mission and vision and main goals and objectives of your organization is. And that might sound wishy-washy a bit, but that's just because what is important to one person or one organization really does differ depending on what are you in business for? What's your main thing? If you're a biopharma company, maybe there are 2 or 3 drugs that are your mainstream sources of income, whereas others are kinda like loss leaders. I don't know. Whatever it is, whether it's economic analysis or market share or operations or functions, or we couldn't do our back office stuff. The point is materiality as it relates to the investor is very important so that they understand the full picture of what's happening. Yes, you need to filter that through counsel, but I guess to sum it up, you need to have an objective standard within your org where you sit down with counsel and your other business stakeholders, and you develop this general definition of materiality that you have. And once you say, okay, we'll look at finance, operations, da da da, R&D, whatever the case is, and say, okay, based on this objective definition, here's how we arrive that it is material, or here's how we arrive that it's not. And of course, over time, as you might merge or acquire entities or your mission and vision changes, does that definition update? Of course, 100%, but you need to note that and you need to note why. But it's a living, breathing thing. But I'd like to say that if you have that standard, it seems far less arbitrary. And because we're talking about information, and of course, what is intelligence? Nothing more than vetted information. If it's good intelligence, then we also have to realize that hopefully we'll get internal standards as to how long information exists, wherever it may be, electronically stored info or even physically stored information, and what the life cycle is for destruction as well. Because depending on what kind of time horizon you're looking at, that info may or may not be there. But hopefully it's not haphazard, because if you fail to plan and if you fail to standardize, boy, that looks not so good in the eyes of shareholders, in the eyes of regulators and others that might be inquiring.
So I think one thing, and again, just kind of playing the idiot that I am, I guess. So I maybe playing's the wrong word, but what I took away from that kind of piqued my interest in the executive suite is to say that materiality shouldn't be defined by your forensics firm. It's an organizational definition of who got breached. And I think that that's something that people probably gloss over because I think it seems obvious to both of you. But I think as a lot of people that come from organizations where IT is really ancillary, I'm thinking healthcare, where it's like, yeah, it's got the health records, but like the medicine is kinetic, right? Like it's a very person to person thing, and IT is records keeping, it's scheduling, it's kind of certainly omnipresent, but it's not what is being sold. I think a lot of experiences I've had where we've dealt with a forensic situation and I'm kind of being the therapist of the executive that's kind of realized just what terrible situation that they're in. They're looking for the forensics firm to help them define that materiality, and I've always pushed it to counsel, right? I've always kind of said, well, that's really a question for your attorney, not for us. So
Right.
I knew it wasn't us, but I think that it's an interesting point that it's not because it should be a lawyer, it's that it should be your lawyer defining it for your organization. It's
Right,
not a legal thing. It is a legal thing, but it's not a thing defined by the law. It's a thing defined by laws and regulations relative to your business.
right.
And I haven't been in those conversations between the attorney and the executives when they're kind of figuring out materiality. but I would imagine that it's got to be frustrating in the same way I know I frustrate executives when they're like, well, how do I build this AI? And I'm kind of like, well, what are you trying to accomplish?
Right.
Right? What's your core business? Like, I'm kind of asking more questions than giving advice. And I know that that always frustrates people about technologists because it's kind of like, well, aren't I paying you to answer these questions? And I'm like, I can answer it in a vacuum, but like, I don't think that's going to create any business value for you. And I think that that was just something that I think I kind of realized in the conversation when I didn't think of it at the time because I'm not the one delivering report to insurance and to customers and to regulatory bodies. Usually your law firm is doing that. So it was really just kind of a natural thing of me saying, well, you should be discussing that with your attorney. It's not because it's law, it's because it's your organization's needs that kind of shape that definition in the context of an incident. And I think we've said that a bunch of different times, but I think that I don't know, I think that kind of clicked for me in a new way as you guys were describing it just then.
Definitely.
Yeah. What Lee said about having some definition internally about like what how do we evaluate materiality is just it's so critical. And one of the things that I've worked as an exercise with with several firms on is just to create, a four, basically a four-part scenario, A, B, C, and D, right? Where we talk about different cyber events and different impacts, right? So business email compromise, where we you know, where a threat actor, ultimately connects to an email account and, siphons off 500, customer records, right? Or PHI records if you're in healthcare or whatever. Create some different scenarios. And then as an exercise, walk through and say, is this material? Why or why not? Right. Because it's way easier, I've found at least, right, to come to a quorum on what criteria are we using or should we be using for evaluating materiality by doing it from a scenario perspective than it is to say, okay, now let's write down the criteria that we're going to use to evaluate materiality. That I don't mean to say that that's a losing effort. You certainly can do that. I've just found higher return on investment by starting from that scenario approach. The great thing about that is if you've done that, when you get into an actual, poop hits the fan, we now need to establish materiality or determine materiality. The question is not from scratch. It literally becomes, is this most like a scenario A, B, C, and D? All right, which one? Because it's most like one of them. And obviously, no scenario is going to cover set of scenarios will cover everything, but it has characteristics of. And then we say, okay, well, did we call that material or not? All right. And okay, well, how do those determinations or how do those criteria that we use there apply to our current situation? And it is so much faster. It's and also you're not really thinking through this very high stress calculation at a very high stress time, right? You're thinking through it first when time is not of the essence necessarily, right? And so there's so many advantages to doing it that way. But Lee, I'm interested. Have you done that with clients? And if not, what are your thoughts around it? Just
I think that's a brilliant idea. The answer is no. I'm used to handling things as lawyers do. But as I think about it, though, if we think about, again, the notion of having the best information, the best intelligence, the best vetted information possible to create a standard of materiality within your org, if we can get the somehow or another in some way, such as through simulation, the critical stakeholders within your org that are the leads for the lines of business that are, just essentially the people that make your business go, that help your biz run from a org perspective, products perspective, all across those critical lines, if you can get them all in the room somehow and get them talking about what matters to them, then in terms of a summation and aggregation of it all those data points, you can get something that's really super robust in much less time as opposed to something a lawyer kind of guesses at based on just them sitting in the room, maybe with their colleagues or maybe talking with a few people. I'd say the approach of getting everyone in the room to dialogue and to refine and to get that going is a superior approach. So I have to say I applaud that.
thank you. I wasn't necessarily looking for that. I was just trying to find out, like, as a lawyer, is this something? Because I've had some kickback actually from a couple of attorneys in the past, right? To be transparent, where they're like, I don't want to document us walking through scenarios here. I don't want to put that in writing in case we deviate from it later, which to me has always kind of felt a little bit hollow. I mean, I do understand it, right? Because discovery is a beast, and you know, but I think the value outweighs the risk in most cases, at least in my experience. So
Yeah, I think that, in terms of when lawyers are resistant, I've been trying to write about this in various forms for years. I feel like when lawyers say no or they, balk at something, 95% of the time it's because there's, not just stereotype, but many, many lawyers are risk adverse because why? We're always
of
concerned
course,
about things like malpractice and things like that. So even for people that are in-house counsel. So as a result, sometimes things that we feel like we don't quite understand, we're much more prone to say just simply no, because we don't necessarily get it. And if you want to add in something that's maybe even a slightly technical thing and that's totally outside the lawyer's orbit, that's not always true, but that's oftentimes the case because lawyers in tech are sometimes like oil and water, although some lawyers are very specialized. So, I just wanted to say it sounds like it may have been a symptom of the lawyer perhaps not getting the value or the logistics or the relevance of what you're doing. But if they have the tools in their toolbox, I'd say to extract those essential elements of information to produce a fairly good working or even a better working definition, so to speak, I'd say, why not do that? Maybe they just don't know the way. Lead them.
I mean that's always the goal, right? Of course, as you're coming in from outside, right? It's always a little bit. I will tell you, as the forensics person, the one person that I don't want to turn off in the room is the lawyer, right? Because they're the ones that are going to determine whether or not you come back to help with the incident or not. If you're there doing tabletop, so it's like it is I hate to confess that often I'm not necessarily acting in their best interest by pressing a little bit harder, but I also don't want to turn them off where you create that hard to work with vibe or whatever. And so, yeah, but good points all the way around.
So I'm curious if because this started to get me thinking on and reviewing kind of while we're talking here some of the verbiage of some of the regulations, which I'll say I've mostly read other people like yourselves summaries of than actually reading the text of because I spend enough time reading other regulations. But I'm curious if I think we've all either seen or heard of people using, well, that's not material as a way to kind of skirt reporting requirements or severity of incidents. And since materiality is so organizationally specific, do we see kind of a trend or a world in the future where materiality starts to become a little more prescriptive of like, in this, if you're healthcare, the following data elements are material. I don't think it can be global. Like I can't imagine an SEC unless an SEC regulation were to say materiality means it affects the share price, which, as Jake pointed out, at least to some degree, that makes kind of everything material. So that would be really complicated. I'm just curious if that's something that because everybody knows about using, well, that's not material as a way to kind of avoid culpability, impact. I mean, there's a bunch of different reasons to do that. Do we see that having an effect on the way that people or the way that regulators start to demand disclosures?
Um, I think that I wanted to answer that in part by talking about a few different perspectives on that. One is, yes, a person can say that's not material, but sometimes I should say, hopefully this doesn't occur a lot, but I know for a fact that with some of my legal colleagues, this has happened. If the attorney takes the perspective of wanting to be willfully blind as to what is going on, that likely in a court of law or within the agency's purview might not pass muster if they want to be willfully blind to just say that's not material, even if a reasonable person in that situation would think otherwise. And certainly there's certainly situations where just in terms of from a visceral perspective, you can perceive or see that a certain situation would be definitely material because it's so egregious not to state that it would be. But clarifying things to help people include things like advisory opinions from regulators that may come out that are non-binding, that may be in response to a certain question, but it's still good guidance. We will, of course, have more litigation, unfortunately, as it relates to the interpretation of these rules and sometimes laws and other things in terms of what's material or what's this or what's that. So cases sometimes form the metes and bounds of either what's binding as to a jurisdiction or what's rather persuasive, even if you aren't, for example, in New York or Tennessee or Ohio or wherever that big case is. There are some cases from certain parts of the country and certain circuits that are deemed to be influential or at least carry a little bit more weight than others. So there's that as well. So it's going to be a changing world. I think as with everything else, the fact that we have to read all the time and keep up with what's going on, you absolutely have to keep current to understand what the definition is today or if tomorrow is 2030, you definitely have to read up to see what's going on there.
Yeah, I think it's an interesting point that even, and I guess where I've witnessed it, there were no regulators, right? It was in an area where it was more of an insurance situation. And I don't know if I would call it willful blindness. That might be a stronger term. I think it might have been like there was a judgment call where the technical staff viewed materiality different than the attorney did. But at the same time, right? Like it's an interesting point that absent a regulator that's going to review this disclosure or a lawsuit that then kind of compels discovery of that situation, then in those two circumstances you can't hide behind a disregard of a reasonable standard as to what would be material. And so I think that is an interesting kind of expensive policing mechanism of that, right? Because that means that you're either taking a regulatory body's time, which they obviously have tons of available time. They've got nothing but time to just review reports, or compelled by a lawsuit, which is, again, as we know, just a very reasonably priced thing to do in America. So it's an expensive enforcement approach, but it is a valid one, and there are any number of, I mean, certainly materiality and DFIR is not the only thing to only have a regulator or a lawsuit police, right? There's tens, if not thousands, of things that kind of fall into that category. I think that's an interesting point, and maybe why regulators have avoided that, because when you start creating binary tests for materiality, you're going to trigger a lot more reports for them to read, and then it starts to become severity as a evaluation versus materiality, which is, again, you've now re-entered the realm of subjective without necessarily solving. If a regulator were to want to create a binary materiality test, they're trying to solve hid people hiding behind lack of materiality. And if you then get a whole bunch more reports and everybody's now super worried about being squashed by the new material prescriptive reg, now you've got to find some new metric to determine how important it is. And you've probably just moved water from one bucket to another. You haven't drained any of that problem. Jacob,
Um,
oh, go ahead, please, Lee.
oh, I'm sorry. I just wanted to add one super quick thing, which is to say, um, as you were speaking, it reminded me of some of the discussions I've had with people on the Hill, like Homeland Security Committee with the House side, etc. And it's safe to say that when major breaches or major events happen with their oversight capacity, they'll want to inquire and investigate. There's sometimes a CISA liaison at the table to ask what they can relay back to DHS CISA, or let's say a regulator's representative might be at the table, even if they're a congressional staffer. So it's certainly the case where the influence of Congress through lobbyists or, let's say, their own internal initiative, so to speak, would also try to move the needle in terms of materiality or these other related things. So I just wanted to highlight that. And Jake, you could take it away. My apologies for interjecting.
Oh, no, definitely. I Please don't apologize. It's fantastic. I was just going to comment on something that we talk a lot about in AI regulation. That and it's a foundational difference between the way the U.S. and the EU typically approach regulation. The EU is very outcomes based, where the U.S. tends to be, for at least technology regulation, tends to be very prescriptive. And because they create, to Matt's point, these binary tests of, you know, you're running this many, parameters and this much memory and this much CPU and whatever. Folks are inevitably, and label it innovation no less, find ways to skirt through the cracks, right? And the SEC is one of the few organizations that I think, by and large, is very outcomes based in the way that one of the few U.S. regulatory bodies. It's very outcomes based in the way that they regulate. I would argue that a lot of the many of, particularly around technology, our regulations are very, very fixed, right? And I very much prefer the outcomes based approach. It does leave some gray area, and I understand where people are like, this is regulatory uncertainty, but at the same time, right? It doesn't allow folks to try to identify these arbitrary binary lines. Matt was talking about it, I think, from the perspective of creating work for the regulators, but I would also note that every time we get those, people innovate their way into complying with the letter of the law without or letter of the regulation without the intent. Um, so
And just first off, thank you both because this has been really educational for me, hopefully for some listeners as well. But since you brought up AI, Jake, so you did it first, not me, I'm curious as to how we see the evolution of particular learning, like large learning models, but really any form of AI in not just in materiality, but in forensic situations in general. And I'm thinking of it more as tools and supportive, not on how do we do forensics in a learning model, because that would be a whole fucking hour for itself. But in more of the supply side versus the demand side in DFIR, what do you guys think of as a future state, or do they have no place here, and only with things that you can discover and query and make testify, then you can't really, you can't make an LLM testify in court, at least yet. That's not where we're at. So where do we see that playing a role in the future of forensics?
like you said, that's a whole hour in itself, right? Look, large language models. The big problem we have here is non-determinism. They are inherently probabilistic models. And we've run a lot of experiments. I'm doing development work for IONS. I'm doing some work with Hunter, right, on AI as well, and generative AI specifically. The thing behind me has half a terabyte of RAM and a couple of A6000 GPUs in it. I'm well versed on the AI side, and the non-determinism of large language models scares the heck out of me in a lot of use cases. Forensics being one of them. And for folks that are not tracking with the non-determinism piece, this is the basically giving data, the same data to the same model again and again and getting different answers. And we've all seen this if you use ChatGPT or Copilot, where you press a little refresh button and you get a subtly different answer. Subtlety matters in forensics. Not just that, but it's contextualizing the information. And that's something that, because large language models don't reason, I hate the data science reasoning. They don't reason the way humans reason. This is a recipe for disaster. But Lee, I'm interested your thoughts on this, because I'm a technologist here, a bit more on that end.
Yeah, absolutely. In terms of large language models from that perspective, yeah, I mean, I oftentimes think about the self-driving car and why we don't have self-driving cars that are actually totally self-driving, because it's mainly that. I mean, you absolutely need a human in the loop. I can tell you that from a public policy perspective, I've seen a lot of AI legislation and other things being proposed. And of course, right now, I don't think that anything will be passed for for this term, obviously. But it's safe to say that just like a self-driving car, it doesn't necessarily know left from right, right? It might know what's probably correct, but it doesn't really have guardrails or context. And that's where I think that people need to be very careful. I mean, is there a place in terms of automation and automated e-discovery as relates to DFIR and everything else? Of course, to some extent, but does it need to be very carefully controlled and monitored and reviewed by a human to the extent that you do automate certain things like e-discovery of electronically stored info? The answer is yes, because there are various reasons, and Jake, of course, knows much more than I do, but there are various reasons why a AI model can be wrong. It could be due to a technical error where it doesn't call a function. It could be due to a fault of some kind. It could be due to the fact that it, you know, there is a certain bit of BS and fudge factor as it relates to AI models as well, and we just never know how much that's being used. They have limited context windows. They can only process so much and pay attention to certain keywords and not others. And how do you know it's fully paying attention? Like I said, folks, if you want to just automate it and just think that that's the solution, again, just think of being blindfolded and being in a self-driving car or self-driving truck on the road. Would you do that down your major freeway? Probably not.
We hope not.
I think there's a lot of people on YouTube that would be perfectly fine with it, but I'm not gonna comment on those people for this. Um, so I think that's all the time we have scheduled for today. So Lee, thank you so much for joining us. This has been really great. Jake, as always, thank you so much. This has been another episode of This Is Fine. Thank you everyone for your time.